So welcome everyone to this webinar. I'm Rafael Carmona from the AAA ICDR. And before we begin, I want to just take a moment of your time to remind you that you can join as an ICDR Young and International Associate or YNI Associate. If you look for our website, ICDR Young and International, you will find it, and there we have registration forms in English and in Spanish. We also have uploaded there the recordings of previous webinars, including the previous installments in this series. If you missed them, you can watch them there, as well as installments from previous years. We also have a LinkedIn group. Again, if you look for ICDR Young and International, you will find it. And we'll also be sharing all of our updates there. I also want to thank our co-sponsors for this construction series, the ABA Forum on Construction Law, the Society of Construction Law North America, as well as Y Construction International Young Construction Practitioners. With that very brief introduction, and since you haven't joined today to hear me talk, but our very esteemed panelists, to whom we're also very grateful that they will devote their time to this webinar, I give the floor to Giorgio, our moderator for the day. Giorgio, the floor is yours.
Thank you so much, Rafa, and thank you so much, everyone, for joining this ICDR Y&I Construction Series webinar, where we will be discussing a comparison of liquidated damages under the common law and civil law. Before jumping into the panel, I'd like to introduce them. First, we have Mary Kate Wagner, who is an associate in the International Disputes Group of Baker Hostetler, where she lends assistance on international commercial arbitration, investment arbitration, and litigation matters. Previously, she was deputy counsel with the Secretariat of the ICC, where she oversaw and managed hundreds of international domestic arbitrations, and she spent her time in Paris as well, and now she's in New York. Next, we have Pirkka-Marja. She's a partner at Lidl in Estonia, and she's considered one of the best arbitration specialists in Estonia, participating in international and domestic arbitrations, both as counsel and as an arbitrator. She's also a member of the Stockholm Chamber of Commerce Arbitration Institute's Council, vice chair of the Arbitration Court of the Estonian Chamber of Commerce and Industry, and she's designated by the Republic of Estonia to serve on the ICSID panel of arbitrators. And last but not least, we have Lars Nümann, who is a partner of the law firm Schäning, Nümann, Specken in Rostock, Germany. He's a German qualified attorney with more than 20 years of experience. He's also a Stockholm Chamber of Commerce qualified arbitrator and member of the DIS German Arbitration Institute. So with that brief introduction, I'd like to set the scene for our panel discussion by having a hypothetical project where liquidated damages is a contractual provision and there's delays on the project that lead to potential liquidated damages being applied. So this hypothetical project is the construction of a powerhouse that helps feed water from a river downstream to a large metropolitan area. As the project is important for the life of millions of people and agriculture in the region, the contractor is required to complete its work in 1 year from the start date. The contract provides if the contractor does not complete its work by then, liquidated damages, or LDs, will be assessed at $3,000 per day. During the project, issues arise regarding the contractor's liability to correctly install electrical cables in the powerhouses, which requires that the work be redone, thus causing delays. And this work was done by the subcontractor of the contractor, who is not in privy to contract with the owner. Ultimately, when the work is finally complete, the contractor files suit against the owner, alleging that the owner's design specifications were faulty. The owner counterclaims against the contractor, alleging that the work of the contractor vis-a-vis its subcontractor caused delay because it negligently installed electrical cables. The contractor then joins the subcontractor into the dispute for indemnification. During the dispute, one of the issues is whether the liquid damages assessed by the owner is a penalty, thus unenforceable, and in response, the owner introduces evidence regarding how it calculated the liquidated damages, prior to the contract being entered into. Importantly, though, this information was never shared with the contractor prior to the contract being signed. Nevertheless, the contract provides terms in stating that the liquidated damage provision is reasonable and not a penalty. The contract between the contractor and subcontractor states that all terms of the main contract, that is the contract between the owner and the contractor, are incorporated into the subcontract, but the subcontract itself does not mention liquidated damages. So with that, I'd like to start with Mary Kate, who will discuss the common law introduction, the common law approach to liquidated damages.
Yes, thank you, Giorgio. That's quite a an interesting and complicated hypothetical that you thrown in there. So, I think what we're gonna do is we're gonna start with basics. And I am assuming that everyone on here knows the difference between common law systems and civil law systems just generally. But one thing I will state about common law is it's it's judicially made. So it's a lot of judges looking at contracts and looking at precedent and looking at what has come before them as opposed to reading a code, which I'm sure my esteemed colleagues will discuss later. So the point of having liquidated damages clauses in construction contracts is really one of ensuring efficiency. It's supposed to be beneficial to both the contractor and the owner by creating a framework within which you know how much you would be paid if there were a delay, and you know how much you would have to pay if there were a delay. And so the first thing you have to start with, as Giorgio says, the main question, which we'll get to, is whether it's a penalty. So the thing you have to start with is the purpose of the clause. So as I've put on this screen, this is liquidated damages constitute the compensation which the parties have agreed. So they agree to this during the time that they're entering into the contract. Should be paid to satisfy any loss or injury flowing from a breach of contract. So in construction contracts, most of the time this is delay in the completion of the project or failure to reach a milestone. A liquidated damages provision is an estimate made by the parties at the time they enter into the agreement of the extent of the injury that would be sustained as a result of the breach of the agreement. So what are the elements of a liquidated damages clause? They must be, first and foremost, reasonably proportionate to the potential loss. And so what this means is it has to be a reasonable forecast of just compensation. And that's determined at the time that you are, as I said, the time of entering into the contract. So it has to be reasonably proportionate, a fair estimate. Again, we are going for compensation, we're not going for punishment. Fair estimate of losses, not a penalty, and it must be in accordance with public policy. So these three elements really work together when you're drafting or dealing with your liquidated damages clause, because if it's proportionate, it's going to be a fair estimate, and if it's a fair estimate, it's going to be in accordance with public policy. So some of the, well, if you could go to the next slide, Giorgio, please. All right, so this is a case from an ICDR arbitration where the tribunal was tasked with determining whether or not the clause for liquidated damages was a penalty or could be applied. And I found the language here, which the court or the tribunal took from the Southern District of New York, which is the applicable law, to be really striking. And some of the language that the tribunal took in their analysis is the word beneficial So liquidated damages must be beneficial to both the owner and to the contractor. And I'm sorry if you can hear that noise. Public policy is served by the implementation of such clauses. In the absence of a contractual provision by which the date for completion of the particular project may be extended, a party otherwise entitled to liquidated damages is limited to actual damages, not to exceed the sum stipulated where himself is at fault, in contributing to the delay. So, although it may be really tempting when you have a construction dispute to look and see what your actual damages have been. The point of a liquidated damages clause is not to go post hoc and say, well, our actual damages were X, therefore we should get X. It's to say, no, when you agreed into the contract, this was a reasonable estimate of what your damages would be. And so we're going to keep everything confined within that context, as long as it is proportionate, and not against public policy. So what are the limits of liquidated damages clauses? So I found this quote, which I found to be very pertinent, and it says, although freedom of contract is the core of construction law, the freedom to contract does not embrace the freedom to punish, even by contract. So we all know, especially in the arbitration community, that consent and contract and all of that is king. But there are these safeguards that exist within the law that don't allow you to punish or to create a situation where your liquidated damages clause will be so outrageous that the purpose of it is not to compensate, as we said, but to force the other party to ensure completion. Otherwise, they will be detrimentally punished, because that's not a balanced, that's not the balance that we're looking for here, when we're entering into a liquidated damages clause. So what happens when a court is faced with a liquidated damage? Normally, what you see in construction disputes is the contractor will argue, if there's a delay or a failure to meet a milestone, the contractor will argue that the liquidated damages clause is unconscionable, i.e., does not fit the requirements that we've been discussing. And so what arbitrators will do, based on the application of US law, is they will look to the essence of the provision. So if you call it a liquidated damages provision, but in essence, it's a penalty, they're not going to give due consideration to the fact that you've called it a liquidated damages clause. They're going to read it and they're going to determine that it's a penalty. That same thing, if you say this is not a penalty, we agree that this is fair, the tribunal can look at that language, assess the situation, assess the contract as a whole, and decide whether or not that's actually punitive in nature. So there is
Mary Kay, if I could jump in. So bringing it back to our hypothetical, if we think about $3,000 a day, and there was a provision in the contract in the hypothetical stating that this is not a penalty, perhaps that, it wouldn't matter, and the courts or the tribunal would still look to see whether, in fact, $3,000 a day is reasonable and not a penalty. And then obviously the court or tribunal would need to consider the fact that this project was importantly need to be done by a certain time, or people in this metropolitan area and the farmers around wouldn't have water. So I mean, these are all facts that the court or tribunal would take into consideration. Is that my understanding?
Yes. The tribunal would take into consideration what the parties' intent was when they entered into the contract. So, if you could repeat the last sentence you said about the damage to the water.
Yeah, so the 3,000, I mean, this project, this hypothetical project was about bringing water to a large metropolitan area for the people and the agricultural areas around it. And so, I mean, it's hard to calculate what those damages would be if the contractor was not able to complete in a certain time. And so I think that's something that the court would, or the tribunal would consider.
Yes, definitely. So the first element of what you said was difficult to determine at the time of entering into the contract. So that is one of the elements. So you come up with liquidated damages for compensation at the beginning when you're entering into the contract because you can't exactly foresee, as in Giorgio's example, what the actual damages would be. And so when we're protecting both parties, beneficial to both parties, you want compensation. And so the $3,000 a day is what the parties, based on their past experiences, based on their relationship, based on their negotiations, have decided that that would be reasonable to compensate them because they cannot determine at the outset what the damages would actually be. And so what the tribunal will look to when deciding whether or not the parties knew, or the parties, when they entered into this contract, had a sense of whether it would be a reasonable estimate of their damages, is whether it was an arm's length transaction, um, a commercial sense of the clause, the party's intention, and the principle of just compensation for loss. So really what the tribunal is looking at is, was there an imbalance of power? Were these sophisticated parties? Were these sophisticated lawyers? Was one not taking advantage of, but did one have a higher negotiating power over the other, such that they may have acquiesced to the liquidated damages clause, which is unreasonable because of their limitations. And so these are things that the court or the tribunal will consider. And so when using Giorgio's example, when looking to see if $3,000 is reasonable, they would also look to the intention of the parties, which is to compensate. They would look to make sure that it's not, as I said, a penalty, which we've discussed is more of a deterrent, because the point of the liquidated damages clause is not to deter a party from breaching the contract, but to create that foreseeability when the contract has been breached. And really, what the commercial sense is, so what the type of relationship the parties have when they entered into this contract. So I want to conclude by discussing, and I'm not sure, I'm so sorry if I'm going over time. No, okay. So I found this, it's an ICDR case, which I found to be interesting. And one of the issues that the sole arbitrator in this case focused on was how the liquidated damages should be applied to the actual damages that were accrued in this breach of contract. And so what that means is you have different types of damages in your contract, as I'm sure my esteemed colleagues will discuss, one of which being damages for delay. And so in this particular case, the sole arbitrator found the liquidated damages provision was enforceable because it was a reasonable pre-estimate of damages associated with a delay at the time the parties entered into the agreement. But what the tribunal or the sole arbitrator did not do was extend the liquidated damages to all damages that had been incurred. So She declined to award so sorry. She declined to award liquidated damages for any portion of time after claimants this was a construction of an apartment building after the apartment had been rented out because those damages were foreseeable at that point. And so the delay that had been caused up to that point had ended, and now there was a reason to go to actual damages. Um, so she states that in the interest of making a definitive, legally appropriate award, and that would not be an impermissible penalty, I find it best to direct claimants to avenues other than liquidated damages in seeking recompense for the problems. So that just shows you that when you have liquidated damages in your clause, you can also, and while they will be and may be capped, while they must be reasonable to the compensation as when you entered into the contract, you can also, while you can't get double recovery, you can also look at your situation as a whole and decide, okay, so this was the delay caused by, or this is the damages caused by the delay that's covered by the liquidated damages clause. We have other damages, and so we will be able to go another route to get those damages. And it's liquidated damages are a really important part of construction contracts, but they're also just one element that can be used when you're drafting your agreement.
Interesting. I really appreciate that introduction to the common law, or at least the United States approach to liquidated damages. It's really informative. Before I move on to the civil law approach, I wanted to let the audience know that if you do have questions, feel free to put them in the chat or in the Q&A, and we'll get to them at the end. Okay. So next we have Lars, who will be discussing the civil law approach, or from the German perspective.
Hello, and thank you very much for being a member of this panel. And I think it's very exciting, and it's been really interesting what Mary-Kate just told us. And what I realized is that we are not that far from each other. We will see that in the end. And I think the approaches are pretty much the same on both sides of the Atlantic. So what the civil law approach comes from is first the law itself. So that's why I decided to start with the law and then go on, and that's why I put up the central section that is regulating damages in the German Civil Code, which is called the BGB. So when you look at that section, it says that a person, first of all, it's the official translation of the German BGB. So I might not be liable for any translation mistakes, but that's how it is. So a person who is liable in damages is to restore the position that would exist if the circumstance obliging them to pay damages had not occurred. That's the general rule. And then you may go on that if you cannot restore the position in nature, you have to pay money. So the general rule in German, in the German approach or in the civil law approach, is that you have to restore the position that would exist, which means that it's a very exact calculation of how damages occurred. So what would be the situation if that situation had not happened? So why we put that in front? Because what we see in the next slide is we do not have a legal basis for liquidated damages in the law itself, but we recognize them as a tool to execute a fixed amount of compensation, that we can ease the burden of proof especially for those who claim the liquidated damages, and that it is intended to simplify the enforcement of a claim for damages. And so we do not have a legal basis in the law itself, but we see it in the freedom of contract, so that the parties are free to agree on a certain amount of liquidated damages and then we have some requirements. If they assume...
Lars, if I could jump in for 1 second, ask you a question. I'm curious about the burden of proof. Who has the burden of proof? Is it a defense that it's unreasonable, and then the respondent, let's say, would have the burden of proof, or is it the claimant has the
well, from the general position, the claimant would have the full burden of proof to prove, first of all, the grounds for the damage, and then the amount of damage as such.
Sure.
And 100% burden of proof. And that is very, very often very hard to prove the damage as such, and to say that in a hypothetical situation, this situation would have been different, and that's why the difference is the damage, and that's why I claim the damage right now. So that's actually what makes it easier to claim the damage, because then you just have to claim the reason for, or you have to prove that there has been a damage, but you don't have to prove anymore the amount of damage that you claim. And when you look at what are the requirements, then you will see that we are, what I said, that we are not so far from what Mary-Kate has already argued how to what is necessary to how to claim liquidated damages. And first of all, there must be an assumption that a damage exists at all. So, well, that is kind of a logical assumption. So if the situation would have been in a normal way, everything would have been fine, and it doesn't, then there is a damage. And then the parties agree that a certain amount of damages would occur under common circumstances. So, and then you have the contractual part in it, that the parties agree to that. And then those parties must have made a reasonable calculation what damage would result from potential breach of contract. So they must have seen before any what they see as a normal way of conduct, what damage would occur in order to estimate the amount. And that is exactly what Mary-Kate has already mentioned. You cannot just fantasize of any amount that you put in your contract. It must have a reasonable ground, and it must be it must put into the circumstances that lead to the contract itself, and to the real circumstances, how the contract was conducted in the end, and how it was foreseen to be conducted, so that the amount is a reasonable amount at the end. So, as I said, we are not that far from what Mary-Kate has already mentioned. So, but in the next slide, you will see that we have the same tension between liquidated damages and contractual penalties, as liquidated damages are meant to be damages or a claim for damages, and not to punish the party or to force the party to not breach the contract. And when you see the clauses in those contracts, it's very often not clear whether the parties wanted to have liquidated damages or contractual penalties, even though they use the term liquidated damages, but in the end, they agreed on contractual penalties. And in order to differentiate between those two terms, the question is whether there has been actually this calculation of damages, and whether those parties have a common ground on this calculation, so that both parties have foreseen it, or whether it is actually rather the way to push or to put pressure on basically the contractor to fulfill the contract in a due way. And that is rather a tool to do that, and not a tool to compensate the estimated damages. And in the construction industry, it's very, very common to put pressure on the contractor, and also very common to use contractual penalties to do that. And very often the parties do not say or do not use the term or the wording liquidated damages, and actually mean contractual penalties, because and then you are also as Mary-Kate already put, you are under the burden of proof to show that the parties have foreseen a damage and the amount of damage, and have foreseen that this would actually occur. And why is it important in our legal environment? Because the difference to the liquidated damages is that we do have a legal basis for contractual penalties. We do not have for liquidated damages, but we do for contractual penalties. And the law says when the obliger promises the obligee, in the event of their failing to perform the obligation to, or failing to do so properly, the payment of an amount of money as a penalty. The penalty is payable upon the obliger being in default. So that is the difference, and that is just to, as I said, to push the contractor to fulfill the contract. The only
So Lars,
precondition.
to be clear, so under German civil law, a penalty could be enforceable as compared to the common law approach that Mary-Kate discussed.
Yes,
Okay.
the penalty would be enforceable. It is, as we see later, it is under court control. It is under the control of the courts as well as of arbitral tribunals, and it can be minimized by them if it's seen as a too high or too unfair or unfair penalty. And when you create or when you write contracts and you use the clauses, and it's very often when you're not sure whether you use the term liquidated damages or contractual penalties, it could be wiser to use contractual penalties rather than liquidated damages, since using the term liquidated damages but meaning contractual penalties could lead to the situation that that the clause is void, because you cannot prove that there's a reasonable calculation of such damage, and then you just use what it is, and you say what it is a contractual penalty in the end. So so that's why this to make a difference between those tools is very important. So when you think of the case that you mentioned in the beginning, I would also go with Mary-Kate and follow up on her arguments by saying, okay, when you have this daily amount of $3,000, and you cannot really show that this amount is seen as a calculated damage or foreseen damage as such, you would rather end up by saying it's a contractual penalty. And then you could estimate whether this penalty is a fair amount or whether it's an unfair amount. So that might be lowered down. But I think it's very important to think before what kind of tool you use when you draft the contract. Other questions, Giorgio?
No.
No, because we already started to see whether there are limits especially in the construction industry, and I think maybe it's if you go to the next slide, especially when you have a look maybe from your point of view and in how we deal with this. First of all, you have to know whether there's a consumer involved, because then you have other problems, and you cannot just put contractual penalties in there and that. But that is not the case in most cases, because you have basically the contractor is not a consumer, so that is just a prerequisite that is
So do you mean a consumer, like, for example, if someone was building their house and they had a contractor, would they be a consumer?
Yes, but then you basically, the contractor is the one who has the contractual penalties. So you put the pressure on the non-consumer side. So that's basically not the problem.
Okay.
And I cannot actually, it's rather a theoretical question, because I cannot imagine an example where a consumer becomes the contractor. So that is just a prerequisite that in most cases is fulfilled. But what we do is we do have a control mechanism, especially when it comes to the contracts, and they are used as general terms and conditions. And those contracts that are qualified as general terms and conditions are like the vast majority of all contracts, because the qualification is done just if you use the clause in like twice, 3, 4 times, then you already are qualified as using general terms and conditions. And if you cannot prove that each clause has been negotiated in essence, and then they are under full control of the jurisdiction, the courts and the arbitral tribunals, and then you have to see whether limits for those penalty clauses, as well as liquidated damages clauses, are in a way broken, especially when courts see unfair treatment, especially when you have, as you usually have, a fixed amount per time unit. Time unit means days, months, and even hours, and a maximum amount that is not set, meaning you usually multiply the amount per day, for example, as we have here with the $3,000 per day, and you do not set a maximum amount. Like you say, okay, we have $3,000 per day, but the maximum amount is, let's say, $100,000. And the time unit itself is sometimes unfair set if it does not set a maximum as well. So everything leads to some percentage that has been set by the Supreme Court, and that is followed by the courts itself and also by tribunals when it comes to, especially to domestic arbitration. And when we talk about construction, it differs from industry to industry, but in construction industry, the Supreme Court has set a maximum amount of 0.5% of the contract amount per day. So that's what your daily limit is. And a maximum in general of the contract sum of 5% of the contract sum. And when you do not put that maximum fix in the contract or the clause, then those clauses are void. So you do not get anything. It's not that you are pushed down to what is seen as a reasonable amount. It's due to the control of general terms and conditions, the whole clause is considered to be void.
Interesting.
So you have to be very careful that you do not exceed those amounts.
Yeah, that's very interesting. So in the interest of time, and I know we're running a little short, we have some other things to work on in this panel. But you make a good point, Lars, about the limits and maximum and how to frame these contracts in the construction industry. And I appreciate, what Mary Kate and Lars have both said, but in the legal that set the stage for the law, and Pirkka, I believe you'll be addressing, what should we consider then? Now that we know what the law is, what do we do to make sure, when drafting these provisions that they're not overturned or found void or found unenforceable?
Thanks, Giorgio, and hello everyone from the Northern European or Northeastern European country, Estonia, and I would say to all the Americans, yes, it is a real country. It's not something made up in Nümann. Having studied in US for a year, I answered this question once a week, I think. So coming to the topic, listening to both of them, I would first say that Estonian legal system is very similar to the German system, but I don't think we make this clear difference between liquidated damages and contractual penalty. In practice, we essentially treat all those terms more like contractual penalty and then apply it respectively. So by and large, everything that Lars said about contractual penalties and all these clauses being enforceable as they are, this would apply in Estonia as well. But again, I don't think we make this difference that if we interpret this in some cases that are only if the words have been used that the liquidated damages, then we would have to prove that there is some damage. I haven't seen this in practice at all, to be honest. So in our case, if there's a contract clause that essentially is that if you breach, there will be liquidated damages / contractual penalty of this amount, then the person that has been the victim kind of the breach has to prove that there has been a breach, and you don't have to prove any damage whatsoever. So this is kind of a small recap from what I heard from the both of you. Overall, the system seems very similar, or the aim seems similar. But now, if you'd switch to the next slides as well, you'd have, yep. Then how do we avoid unenforceability? I think this is a big question that we will never be able to answer today. And definitely there are always so many buts and questions and corners and nuances that play into the whole thing. So all I can say maybe is to lead you to some, I don't know, checks to consider when you are preparing, and then later on also when you are having a dispute on the case. So needless to say, I think there are differences between civil law and common law. We need to keep this in mind. And what's especially important also is that there are differences within civil law very clearly. I think there are some differences also between UK and US. I wouldn't be able to comment, but they are there to my understanding. But definitely, I think both Lars and me, we are representing the kind of Germanic approach of the civil law. I'm not so sure that the French see everything the same way as we have discussed, nor the Spanish or Portuguese. So keep that in mind. Now, one key element is know the applicable law. Don't assume. Don't assume that the terms that you read in the contracts are actually what you think they are, because it might very well be that if you have an international contract, then the parties very often use English language, have it in English language, and then they just use the terms of the English language without maybe knowing the nuances of the UK or US law that actually are behind this term. So it's important to understand what law you have, what are the limits, what are the practices. And then a little bit from the next step that is important to know also from when you're drafting or when you're negotiating. But Lars little bit touched already upon the interpretation. And I think Mary-Kate also used the word intent. But it's very important to understand that if we have a text as a contract, then this might not necessarily be the key, because under the civil law and for example Estonian law, it's the actual common intent of the parties that is important when we start interpreting what has actually been agreed on and what are the limits, where are the caps and all those things. So it might even be that the actual words say something else, but if in the end one party is able to prove that the intent was totally different, then this might actually prevail in interpretation. So from this point of view, it's important to understand that already when you're drafting. And it's important, the other factors that play in is how did the other party understand the clause that you reached? What's the purpose of the clause? Also important is what's the prior practice between the parties. For example, if we have a liquidated damages clause and the parties have for years interpreted it as typical contractual penalty that has a motivational side in it, then it might be very difficult to argue that it's liquidated damages and not contractual penalty, even if there is a difference. And of course, in many cases, it always boils down to reasonable personal interpretation, so that what does a reasonable person in the same circumstances conclude, or how would a reasonable person understand this contract?
Pirkka, I have a question about the intent. So if you're drafting a contract and you want the intent to be known in the contract itself, in the text, I mean, do you advise or think it might be reasonable to have something in the provisions saying it is the common intent of the parties that this is a reasonable estimate of foreseeable damages for each day of delay, and this is not to be construed as a penalty? I mean, or would that be enough, or could one argue that no, that's not actually the common intent of the parties?
Well, both are the right answers. In the one sense, if you have something like this in the contract, then it's easier for you to, if it's your intent, it's easier for you to argue later on and to prove that this has been something that must have been known to the other party. They must have understood it this way because I flat out told you that I understand it this way. But if you don't have it, this is not the dead end, in the sense that you would also end up with emails, drafts, who proposed what, how do you, why they were deleted, why the wording was changed at some point, and so on. So if you have in the emails that, okay, let's keep this wording, but just so you know it, I understand it this way, and you can later in the dispute dig out such email, then highly likely you bend it towards yourself, how you would need it to be interpreted. So if you could put on to the next slide as well. So what it all boils down to in what I said is that it's important to actually negotiate. It's a very trivial thing to say, but actually it's important to negotiate. It's important to express what's important to you. What are the aims of the, let's say, liquidated damages for you? In many cases, the aim of the liquidated damages, it's not just burden of proof. It's that for sure as well. I mean, usually there are two aims: burden of proof, making it easier and making sure that you don't have to be able to prove the damages or deal anything with the damages. If it's a breach, it's a breach. Or then it's also the motivational part is that sometimes the liquidated or contractual penalty that I would use it mostly is just a little bit higher maybe than the possible damages that you might estimate, because you express during the negotiations that it's important for me so that you wouldn't just, you know, pay the cost, but it has to be something that motivates you. And I would make the difference between punishing and motivating. That motivates you to actually fulfill the contract and make sure that you will do everything by the time. So with your example, $3,000 per day, like if does this match exactly the estimated risks, estimated damages, or is there includes maybe a little bit something extra? It's important that you express this during the negotiations so that both parties understand what's the aim of the contractual penalty. And this would be later on assessed also by the courts or arbitration tribunals, as Lars said, regarding the foreseeability and reasonability. And it's, I mean, it might be reasonable if you know that it's also has this motivational intent. The reasonable amount might be higher compared to it's just damages that you're trying to ease the proof. So Lars already touched about the standard terms and negotiated terms. I think this is very important to understand because in both in German and in Estonia, and I think we are by and large the main countries this extreme with it. I think in the Nordics the standard terms are not as extreme, and I also think that in France they are not that strongly kept. But also in Estonia, the Supreme Court has said that if you have 5+ similar contracts, then you essentially have a standard term, and then anything in those terms that is detrimental or kind of might be harming the other party unreasonably might be void just like that. So it's important to understand in many construction contracts we have references to FIDIC, we have references to all kinds of construction rules, and they very often include all this terminology and all the contractual penalties, damages, and all that. So it's important that you actually follow the standard term, how to put it into place to actually enable the other party to get to know what are those standard terms, because otherwise it might be scratched out just like that. Another thing that I want to really highlight is public procurements, because many big construction projects have public procurement elements in it, which means it's not you that controls the contract terms and their interpretation, but rather a public entity. And it might very often be that what comes out from the tender terms, it's vague. You don't really understand that. I've been in a situation where we have really, with all law firms from Sweden, Estonia, and Finland, we've tried to figure out what it means in the FIDIC context, half FIDIC context, and then Estonian law applicable into English language document, basically. And it's very difficult to understand what has been the aim overall. And then we kept asking the government, so what are they, how do you interpret this in this term? And the answers come back so that they are kind of opposing or contradictory. And then it's, in this sense, it's, I don't know, in many cases, it's actually impossible to see what's the common intent. It's what the government intended, who knows that? But you have to be careful with that. Of course, the prior calculations, as I understand from Mary Kate, are important for the UK point of view. I don't think in our case they are that important. Lars might correct me regarding Germany. In our case, mostly one party who would benefit from the contractual penalty, they would, of course, or both parties would have the kind of risk calculations, not necessarily monetarily, but risk calculations in their minds, but they are hardly ever directly like discussed with the other party. Sometimes they are, but it's more like, okay, this might be it. Let's drive this to this amount. And again, the motivational thing, I think is important, the encouraging performance. And I actually do have a question before I end to Mary Kate, because I'm, after listening to you and after all these preparations we've had, I'm still puzzled with the difference between motivational / punishment under the UK or common law. I'm not very sure whether I understand where it is and how it is. And now, before giving the floor away again, I would just say that all of it, what I just said, is just a nice talk, unless you're able to prove it. So already during the negotiation phase, make sure you understand that if there would be a dispute on this and this, you would have emails, you would have drafts, you have comments, you have some references to prior practice and so on, so that you actually understand and will be able to prove why you think it should be interpreted as it is. Thank you.
I appreciate that. Thank you so much, Pirkka. And it's a really good question that you posted, Mary Kate. I know we have a couple more minutes left. So Mary Kate, if you could answer that question, briefly, but there was another question from the audience for Lars. And under German law, what the question is, could you have both the liquidated damages clause and a penalty amount? Which is an interesting question. But Mary Kate, if you could just answer briefly what Pirkka asked, and we'll jump to Lars.
Yes, that's actually a great question. And I don't know if I have an adequate response to the difference between motivation and penalty. What I will say is, when you're entering into the contract, it's more about foreseeability and just compensation, as opposed to ensuring that the contract is completed. So one court has said payment that is intended, liquidated damages are payment intended, back up. A penalty is when payment is intended to spark compliance with goals of the contract, which reveal the punitive nature of the payment obligation. So I would say that the difference between motivation and punishment under a US perspective might not be very different. And it might just be, motivating may actually be a punishment.
Okay.
Yeah,
So
it's
be cautious of having any motivational element in it.
Yeah, there's an interesting aspect to it. If you are a contractor and you see that, wow, based upon what I'm doing right now, I might not be able to finish in time and I'll be in delay and I'll have all these penalties or liquidated damages coming my way, I might start being motivated to ramp up my work and accelerate my work, even though I wasn't directed to. And that might have risks, including doing the work in a rushed manner and leading to defects, or maybe having to increase your costs and hire more labor to get the work done. But good question.
Sorry, I was just bouncing off of that really quickly in terms of motivation. I will say, and Giorgio, you just sparked this idea in my head. What may be motivating is for the contractor, the subcontractor, to request those extensions of time so that they don't actually incur a delay. And if they know that they're going to hit the liquidated damages once they incur that delay, it may motivate them to be more proactive in actually the organization of the timeline of the project.
Thank you. And Lars, if you could answer the question, then we'll conclude. Thank you.
Yes. The question is whether you can have both liquidated damages and contractual penalties in one contract. The answer is yes, but you cannot use them both. You have to deduct one amount from the other. You cannot ask for both. So if you are in the situation where the contractor is in default, you better think of what is the better alternative, the contractual penalty or the liquidated damage, because you cannot claim them both and accumulate them and sum them up. So that would be considered as unfair. And that's why we have not a clear border between liquidated damages and contractual penalties. They just very often, as Pirkka said, they are very often used together in a way. especially in the mind of the people.
Perfect.
I
Thank you.
wanted just to add before you end that we didn't touch upon it, but under Estonian law, at least, the law very clearly says that even though you have a contractual penalty, you are allowed to claim damages exceeding the contractual penalty. So the contractual penalty as such, or liquidated damages, if you use this terminology, is not treated as a cap to damage claims.
Yeah, it's interesting. I mean, and that underscores how important it is to know the law, especially if you're from common law and you're dealing with a civil law contract and vice versa. So thank you all so much for being part of this panel. I really appreciate the time and effort to go into it, and thank you so much to the audience for participating, and to the ICDR YNI for hosting. If you have any other questions about the panel and to the audience or to the panelists, feel free to reach out to them, and I'm sure that they would be able to offer some thoughts. Thank you.
Thank you so much, Giorgio.
Thank you. Bye-bye.